I've gotten a lot of interesting records of the before, during, and aftermath of this mess, a mess that was needlessly created by the exfiltration of these Saudi students by their government, with the help of others. There are a lot of receipts, but getting them wasn't always easy. For instance, here's me, in court, made to sue to get the hit-and-run body cam footage and the complete police file out of the city of Portland, whose attorney disagreed with me about the meaning of the word everything.
My intention when I did file the records request was for everything. I wanted to see everything that there was in that file that could be subject to public disclosure. I'm not trying to get anything that isn't subject to public disclosure. What I am trying to do is just get everything that is. And defendant has left me with no means to know when I've reached the bottom of that barrel. And I just want to say one other thing, because I think that is generally my position on this. Everyone, I think, is familiar with the criminal case that came from this hit and run incident. I've gotten a lot of records related to this incident and the court case. I've gotten them from Office of State Court Administrator, the State Bar, the Department of Public Lands, the Office of Public Defense Services, Hood River Sheriff, Multnomah County Sheriff, Hood River Police, and this very circuit court, and I have had no problems.
Well, I won that lawsuit, was awarded fees, and even got the judge to rewrite the city's evasive order. But let's put a pin in that for a moment and go back to 2019, when attorney Ginger Mooney's pattern was finally discovered and she became a national story. Pretty much the day Mooney became front page news, she lawyered up and screamed, "Danger."
There was an article run about me today in the Oregonian, and so now I've started to receive death threats.
Mooney's lawyer later elaborated that they were threats hoping she would be raped and murdered. Those are absolutely repellent views, but they are not threats, and both lawyers should have known that. Regardless, Mooney used her danger narrative to shift attention off herself, and it worked. As the story picked up steam and the media turned its attention to the Saudi government, I focused on the money. In many of these cases, Mooney had her clients claim poverty in order to receive state funds for her expenses, and most of the judges approved those applications. So even though these defendants had a privately retained attorney and had easily posted large bail amounts using checks issued by their government, they somehow qualified for funds that are supposed to be reserved for the truly needy. Staff from the agency that oversees these funds called it problematic. Because the Saudi government coordinated Mooney's representation of the students, we can be pretty sure that they also paid her, meaning that she was not getting checks from 4 different families. Had they each been paying her, then there undoubtedly would have been leftover funds in her trust account after they fled and stopped taking her calls. Those funds would be considered abandoned, and abandoned funds such as those are supposed to be reported to the Department of State Lands. Mooney made no such reports after her clients fled. The alternative would be that Mooney spent their money down to the penny in all the cases, which would be quite a coincidence and an entirely different ethical problem. More on that later. Then there's the biggest bag of cash, the money paid as bail. In Oregon, when a defendant posts bail and then fails to appear, certain things are supposed to happen at certain times according to state law. Yet in Mooney's cases, everything went entirely wrong, and it all went wrong in a way that's hard to overlook, particularly since it went wrong in 3 separate courts. In Benton County, after child porn aficionado Al-Harthi took off, Judge Donahue only ordered the 10% forfeit. Mooney confused the issue by submitting an exhibit that didn't match the court's record. Her funny paper made it seem like Uncle Faisal had paid Al-Harthi's bail, not Faisal from the Saudi consulate. Despite that, the court did send the notice of forfeiture to the correct place. In Multnomah, Noura paid bail using a government check, yet was allowed to claim that he had made bail on his own. After he fled, the money just sat there untouched for 2 years, and I'm sure there was a court staffer helping it stay forgotten about. Then I pushed another reporter to inquire about it. Almost instantly, the mandatory notice popped out, but it was sent to Noura at his Oregon address. And after that, a judgment against Noura for $1 million was finally entered. Close enough, I guess. Then there's Polk County, where accused rapist Aldoways fled in 2015, just weeks after Mooney and Judge Sally Avera negotiated how much his release would cost the Saudi government. After he took off, Avera issued a bench warrant, but she didn't check the box forfeiting bail. No warning notice was sent to anyone, and bail was not released to the state. That money is still sitting in Polk's hands, even after I poked the court in 2020 and even after I got the Oregon State Police involved. There has been almost zero accountability for those involved in this mess. It's actually alarming how easily law enforcement is deterred from investigating public corruption. For instance, Heidi Biddick was the Polk County Trial Court Administrator in 2015, and that's her handwriting on the bail receipt in Aldoway's case. In 2019, she told me that the $50,000 bail was still being held in the state of Oregon, which is some evasive wording. I mean, is the money in her and Judge Avera's cookie jars? Biddick was fired in 2020 for misuse of official funds and because money held in the court safe went missing under her watch. The bulky investigation report of her bizarre whistleblower retaliation claim shows just how hard it is to get a court employee fired, even when they steal. Is Biddick the reason that Polk won't release the money? Because it's just gone? It's not a stretch to believe that high bail was used as a bribe in these cases in exchange for release conditions that were favorable to fleeing the country. Nobody would steal money if they weren't sure that nobody was going to come around asking about it. Another Polk staffer out of a job is Sally Avera, who was apparently asked to resign in 2017, halfway through her first term as judge. We can presume she was softly fired because she had previously expressed interest in being a judge for as long as voters would have her. Her bonkers retirement letter read like someone begging to be allowed to stay on. That's understandable given how lucrative a job it was, apparently. There was no internal investigation into the disappearance of high-profile defendant Noura, so Multnomah Sheriff's Deputy Kari Kohlberg suffered no fallout, which is perhaps the most disappointing failure of accountability in all of these related cases. Given that we still have questions about who the actual driver was, we can determine that the Portland police did not do a good enough job investigating the hit and run of Fallon Smart. And maybe that's why there are still things missing from the police file I received. I wonder what the undisclosed records show, but also how they got away with concealing them in violation of my court order. There was also no apparent fallout for the Benton court that was holding the passport of Al-Harthi, who was later discovered traveling with said passport. Speaking of him, unlike other defendants who have been spotted living their best lives on social media, such as Noura, accused child porn enthusiast Al-Harthi is undoubtedly not faring as well. That is, if he's still alive. And about those air ambulance flights. There have been 2 more jaunts to the U.S. since my last episode. One that sat in Albuquerque for 2 days, and another that was parked at Dulles for 4. Both were specifically labeled medevac, so the State Department and FAA should take a hard look at those receipts, because those did not seem like medical emergencies. And that brings us back to Ginger Mooney, the lawyer whose pattern went unnoticed for so long, but who eventually ended up at the center of a national shitstorm. Did Mooney have an ethical obligation to stop accepting new clients brought to her by the Saudi government, given their track record of illegal exfiltration? If so, when should Mooney have put her foot down? After the first student fled in February of 2015, or when the second one took off that April, or how about the third in December? Certainly, by the time the fourth fled, an ethical attorney would have sat their client down and had a difficult discussion. Client meaning the Saudi government. But clearly she did not do that. She continued to cash their checks and defend Noura's case and accept 2 more of their students and handle their passports. In 2020, Seth Smart filed a bar complaint against Mooney because he believed that she was hired specifically to enable Noura's escape. Mooney's ethics defense attorney, David Elkanich, called Smart's complaint offensive for bringing up Noura's nationality, which is not at all what the complaint was about. It was about ethics. Elkanich also doubled down on Mooney's imaginary victimhood while loudly braying about her equal representation of defendants, regardless of their color, their gender, etc., as though someone had filed a diversity complaint about her. Talk about deflection. Elkanich also claimed that Mooney had no disciplinary history with the bar, but that was false. In 2010, Mooney was tinged for accounting issues plus failing to safeguard client property, which sounds a lot like her Saudi problems. But the craziest BS in Elkanich's response was a footnote in which he name-checked me, called me a harasser, and went full tinfoil hat, claiming that Smart and I were in a conspiracy or something because I had scooped other media on the bar complaint story. It would take a whole other episode to unpack it all, and someday I may do exactly that. I filed motions in the Polk, Benton, and Multnomah criminal cases to get confidential material unsealed. Elkanich appeared on Mooney's behalf twice, despite the fact that she was still the attorney of record in those criminal cases.
Is she representing the defendant in this case currently?
Your Honor, I don't believe I can answer that question for you.
And can you explain why not?
I would believe that anything relating to her specific representation or not representation would be protected by RPC 1.6, which is her duty of confidentiality.
But you're not able to tell me whether she represents him or not.
What I can
put her in a very awkward position.
Your Honor, this entire proceeding is an awkward position to some extent.
He had a better answer on tap for the second hearing, but I was still able to get David Elkanich, allegedly Oregon's top legal ethics attorney from the national firm of Holland and Knight, stricken from that record because nobody appeared for the defendant in a matter that materially affected his interests. Both Elkanich and Mooney should have been tinged for the unsealing debacle alone. Instead, the Oregon State Bar quickly dismissed Seth Smart's complaint against Mooney, clearly wanting to sidestep the entire mess, which is not what one wants from a regulatory agency. This is not the first time I've been forced to point out the bar's failings, but they should have investigated at least a few issues. For starters, it's unethical for an attorney to assist with a defense that they know is false, like one that is designed to protect a real guilty party. It sure seems like Mooney was developing a workaround so that she could get Noura off without having to admit that someone else was the actual driver. Another problem was a possible conflict of interest for her between her clients, and she had different and likely adverse responsibilities to both. Also, if the state doesn't want the Saudi bail money, doesn't Mooney have some sort of ethical obligation to advocate for its return? The fact that Mooney is still the attorney of record in most of these cases and never withdrew from them tells me that she has to stay put for some reason, probably something to do with bail. Let's take a brief look at Noura's docket, the only Saudi case Mooney left. She filed a motion to withdraw 2 years after Noura fled, but exactly 30 days after the court finally noticed bail still sitting there. Mooney was not permitted to withdraw at first. Her co-counsel was let out within weeks of submitting his motion, but not Mooney. It was almost like someone at the court was keeping her there for a reason. They finally let Mooney withdraw, but it was timed right after my motion to unseal was filed. The timing has more than a whiff of cause and effect, and that is really hard to ignore. Judges don't just suddenly forget how to set bail or how to deal with it when a defendant takes off. Court staffers don't just forget how to handle passports and are never bewildered when a motion is filed. Sheriffs don't just forget how to monitor defendants or how to accurately write down who wrote a $100,000 check. State agencies don't just forget how to regulate the legal profession, and ethics defense attorneys don't just forget how standing works. It's like everyone within a 10-mile radius of these cases, across multiple counties, just suddenly got very, very stupid. And that's what public corruption looks like in practice. It masquerades itself as bumbling, all thumbs, 100% incompetence. It's quite an effective diversion, too, especially when there's an easier scapegoat on hand that everyone can be mad at.
And there are people here in our legal system that allowed, either facilitated this lack of justice to happen, or at least look the other way, didn't do their job, didn't investigate fully, didn't, make sure that we had a chance for a semblance of justice. And I think that for me, that's really hard. It's really difficult to grapple with that. That's how the system works. And
Fallon deserves a measure of justice, and her family deserves it too.
she didn't have, a mean bone in her body. She loved everyone she came in contact with. She'd never gossip or talk trash about people. She was always just would look for the positive in people and in situations. And even in crummy situations, like I said, always singing a song. Like if we're doing, chores at the house or housework, like she's singing a song while we're cleaning up dog puke or whatever it is, she was just that kind of person that, if I were in prison, I'd want her to be my cellmate because she'd make it so we could get through that. I work with literally thousands of kids, and she's one of the absolute best I've ever met.